Hello, San Antonio Baptist Association. It is great to be back with you. Unfortunately, not in person, but I appreciate the opportunity to come speak with you again. I wish we could all be gathered together, and I look forward to the day that we get to do that again. My name is John Litzler, and I am an attorney with a nonprofit group here in San Antonio called Christian Unity Ministries. I have been here to SABA for the pastor lunches several times, and I've met most of you, and I enjoy the opportunity to serve churches in this area involving legal issues and the ability to do that. This morning, we're going to be talking a little bit about religious liberty, and we're going to be talking about that in connection with the July 4th holiday, Independence Day, that's coming up. So we're going to be sharing a little bit about that. I've titled this talk, Our First Freedom, Disruptions in the Disruption of Religious Liberty. And that word disruption for religious liberty has a couple of meanings. First, that the institution of religious liberty, when we were founded as a country, was a massive disruption and something that was new. I won't go too much into that because I know that there are some other talks about the history and the Baptist contributions to religious liberty and how Baptists have their principles of freedom of conscience and those type of bedrock religious liberty principles helped form our First Amendment. And then there's another issue, which is the disruption that's happening to religious liberty right now. What's the current state of religious liberty in America? And so we're going to spend most of our time talking about that today. But I wanted to share with you first a quote that I think really captures how disruptive this idea of religious liberty was when our founding fathers adopted the Bill of Rights in this First Amendment. It's a quote from a sermon from George W. Truett, an excerpt from his sermon he gave in 1920, in which he said, "Years ago, at a notable dinner in London, that world-famous statesman, John Bright, asked an American statesman, D.L. Curry, 'What contribution has your America made to the science of government?' To that question, Dr. Curry replied, 'The doctrine of religious liberty.' After a moment's reflection, Mr. Bright made the worthy reply, 'It was a tremendous contribution.'" So you've got this scene with these two statesmen, one from England and one from America, and the statesman from England is saying, okay, you fought your war, your Revolutionary War, you've won your independence, you're now in a nation. What's so great about your government? What have you contributed to the science of government that's so different from the way we do things over here? And the American statesman, D.L. Curry, says, the doctrine of religious liberty. That's the new thing. That's this separation of church and state, this idea that the government won't either favor or establish a particular religion, nor will they prohibit the free exercise of religion from others. And what a great contribution it was. For our talk today, I think I want to share with you a guiding principle, something I think that we need to keep in mind as we go through this discussion. We're going to look at a lot of different cases, legal cases, because I'm an attorney, and when I talk about the modern state of religious liberty, I look at the legal cases and what the courts are doing and what's being decided to determine that. Where are liberties being upheld? Where are they being challenged? And so we're going to do that. But one guiding principle I think would be helpful for us all to keep in mind is that we need to be careful not to confuse loss of religious privilege with loss of religious freedom. And what I mean by that is Christianity has held a privileged place in our society since our founding fathers wrote the Declaration of Independence in our Constitution. Christianity has been the predominant religion in America. And while it may still be the predominant religion, we're moving into a post-Christian type society and culture where Christian churches and other institutions may not always be given the benefit of the doubt. They may not be given the same privileges they were given before. So we need to be careful to not confuse situations where the Christian churches are treated the same as atheists or agnostics or other denominations or other religions, and not confuse that with loss of religious freedom. Loss of religious freedom is something different. We're going to look at a lot of very specific cases and challenges to that today, but I think that's a good thing for us to have in the back of our mind as we move forward. And so one of the cases that I think kind of exemplifies that distinction and is a really important case for us to talk about is a recent Supreme Court opinion that came down just last Monday, June 15th. So it's a very recent opinion. It's called Bostock versus Clayton County, Georgia. And it's actually a consolidation of 3 separate cases, but they all kind of ask the same question. So the Supreme Court considered them all together and ruled on them all together. And the questions that they asked were, there's under Title VII, is discriminating against someone because of their sexual orientation or because of their gender identity, is that legal or is that illegal? Does it violate Title VII? And when I say Title VII, that's a shorthand way of talking about Title VII to the Civil Rights Act of 1964, a really important piece of legislation in American history that prevents discrimination in employment situations. That's what Title VII does, on the basis of certain protected characteristics about a person. If you have those protected characteristics, we call that a protected class. So the big one in 1964 was race, but it also applies to not discriminating against someone based on their religion, based on their gender, based on their ethnicity or national origin. And then later, these aren't addressed specifically in Title VII, but there were some other acts that came along and did the same thing. The ADA, which prevents discrimination based on disability, the Americans with Disabilities Act. The ADEA, which prevents discrimination based on age. So some other protected characteristics. And so the question in these Bostock cases were, when we're talking about sex and not discriminating on the basis of sex, does that include your sexual orientation and your gender identity? And the Supreme Court decided just last Monday in a 6-3 decision, 6 of the justices took the majority and said, yes, it does. It prevents discrimination based on your sexual orientation or your gender identity. It was a tremendous opinion that reverberated deeply with a lot of LGBT groups. And while it was not directly a religious liberty case, it was not a religious liberty opinion, it's going to have tremendous impacts on religious liberty. So the question is, when the court does this, when they recognize these types of rights, when they look at a case like Bostock and say, yes, this applies to the LGBT community, then the question is, now how do those rights interact with our religious freedom? What happens when we have seemingly competing rights or rights that are at odds with each other? Because I'll tell you, you'll see this throughout the course of our talk today, but under this court, this Supreme Court with Chief Justice John Roberts, it's a very pro-liberty court, all kinds of liberty. Pro-liberty for individuals, pro-liberty for sexuality and marriage, pro-liberty for business, and pro-religious liberty. And so they keep ruling, the court keeps ruling in favor of the corporation or the individual asserting their liberties. And so what happens when these liberties seem to be at odds with one another or come to a head? And that's exactly what the court's going to have to get into next. It's already happening in some cases. And that's the question that's going to come after this Bostock ruling. Like I say, this case wasn't directly about religious liberty, but it's about to be. It's going to be cited in a lot of future cases. And so some people asked that. In the oral arguments, in the briefs, some folks said, if you rule that sex includes sexual orientation and gender identity, what does that mean for religious organizations? What does that mean for religious freedoms? And Justice Neil Gorsuch, who wrote the majority opinion for the Supreme Court, wrote this. He said this in the opinion about those concerns. He said, "We are also deeply concerned with preserving the promise of free exercise of religion enshrined in our Constitution." And then he cited 3 different legal doctrines. Some are actually written laws. Some come from the First Amendment. He said, these are 3 things that protect religious employers and organizations when they're hiring and making employment decisions that would fall under Title VII. First, he said, there's an express exemption for religious organizations under Title VII when they're discriminating based on religion. Religious organizations can discriminate based on religion when hiring. Second, he said there's this doctrine that the Supreme Court, have recognized called the ministerial exception. And that doctrine comes from the First Amendment. And then third, he said there's this super statute called the Religious Freedom Restoration Act. We call it RFRA for short. That was passed in 1993. And that super statute also protects religious organizations in hiring. So I want to talk about each of those 3 in turn, what they are, how they come into play, what they could mean for your religious organization, and why you need to know a little bit about them, especially when it comes to the area of employment. So Title VII, again, which is Title VII of the Civil Rights Act that addresses employment issues, specifically says this. It says that statute does not apply to a religious corporation, association, education, institution, or society with respect to an individual's religion. And what that means is all of those groups, not just churches, but all kinds of religious affiliated groups, including schools and other institutions and societies and things like that, they can discriminate based on religious beliefs. And that's an important thing and a powerful thing, and it's not limited to your pastor or your ministers. It's anyone that works for that organization. So if you have a ministry assistant and that doesn't share the religious beliefs of the church or the organization, you can absolutely refuse to hire that person or terminate that person because their beliefs don't line up. Similarly, with a custodial, someone who does custodial services, even if their job duties are purely secular, even if all they do is move and set up equipment, open the doors, clean the facilities, make sure the facility is available, that kind of stuff, arrange and set up rooms, all those duties are secular duties. They're not what we would consider religious duties, but even then you can require that those individuals share your religion and your religious beliefs. So a very broad protection in that area in one sense. In another sense, it's a little bit limited because it only allows churches to discriminate based on religious beliefs. But what about when religious beliefs overlap with one of the other protected areas of classes? For example, sex. And what happens when those two areas overlap? And that can overlap with sex in several different ways, right? It could overlap based on gender, whether you're male or female. What if a church doesn't want to consider a female candidate for their head pastor position, their lead pastor position? In some ways, that is discrimination based on sex, on the gender of that person. In other ways, it's discrimination based on religion, religious beliefs about who should be the lead pastor at the church and what the Bible says about that. Similarly with sexual orientation and gender identity. In some ways, it seems like it's discrimination based on that person's sex, about who they're attracted to or whether they identify as male or female. But in other ways, it's really about religion and what the Bible has to say about sexuality, or what the church believes that the Bible has to say about those things. So what happens in those situations? Well, there's another doctrine that Justice Gorsuch points to in his opinion, and he calls it the ministerial exception. And that's because the Supreme Court recognizes the ministerial exception. There was a case back in 2012, and here's what it says. This is under the First Amendment. It says that it bars application of employment discrimination laws, so bars claims under Title VII, to claims concerning the employment relationship between a religious institution and its ministers. Now, this one on its face is a little bit more narrow because it applies to that religious institution, that school, that church, that organization, that association, with respect to its ministers. And this isn't a statute. It's not something Congress wrote like Title VII. This is derived from the First Amendment. It's implied in the First Amendment freedoms that you've heard about and learned about the free exercise of religion. It's implied that churches get a say-so for discrimination when hiring their ministers. And so the question then becomes, okay, what types of religious organizations? What constitutes a religious organization that benefits from this? And what does the word minister mean? Because we have so many different names depending on your denomination or your faith group. You may call them clergy or priest or pastor or rabbi. What are we talking about when we use words like ministers? You might call them a bishop or something else. So what are we talking about? Who does this apply to? And the Supreme Court didn't decide in that case. Now, that was a unanimous decision. It was called the Hosanna-Tabor case, and it dealt with a Jewish day school and the right of that school to discriminate when making employment decisions. And so it was with a teacher. And so right there we realize this isn't limited to what we think of as Baptists. When we think of ministers or our pastors, we think of our ministerial staff not including maybe our early learning center teachers, or maybe not including our associate staff, our support staff, our ministry assistants, administrative assistants, that kind of thing. But this is interpreted more broadly than that. And we see that right there in the Hosanna-Tabor case, where it applied to a school, not just a church, and applied to a teacher at that school, not just the licensed and ordained ministers, not the way we think of when we think of someone who's licensed or ordained typically. So it's broader than the name ministerial exception applies. And so to really get a feel for how it's been applied, there are 4 factors that the Supreme Court gave in that case for determining who's a minister. No single factor is determinative, and so we don't know exactly how they balance, but they gave 4 factors, and here are what the 4 factors are. The first is the formal title given by the religious group, whether you call them a minister or pastor or ministry assistant. The second is the substance reflected by that title. Does it reflect some type of education or training or degree? The third is how the employee uses that title. Do they behave as though there's important religious function to their work associated with their title? And the fourth is the important religious functions the employee performs for the religious group. And in that opinion, the Supreme Court relied heavily on the important religious functions that teacher did in teaching the religious beliefs of the school. And some of the justices, two of the justices, Justice Alito and Kagan, writing separately in a concurrence, even though that was an 9-0 opinion, they wrote separately to say, this fourth factor, the important religious functions, that's the most important piece. Do you do something religious on behalf of the organization as opposed to purely secular work? And so, as I mentioned earlier, this Bostock opinion, while it was a big opinion that came down last week, it wasn't a religious liberty case, and so the court didn't get into what if this had been a church that was making this employment decision? How would things be different? By the way, in these three cases, the first case, Mr. Bostock played in a gay softball league, and when his employer, Clayton County, found out about it, they terminated him. Now, the county claimed that it was because of conduct unbecoming an employee and that conduct had to do with misappropriation of funds. Mr. Bostock claimed that was all just a fake claim, a pretextual reason to discriminate against him because of his sexuality. And just for the other two, just so you can know, one involved a man who was skydiving with a woman. She claimed that he had assaulted her. He was trying to ease her fears about that, letting her know he wasn't trying to touch her inappropriately. And he said, I'm gay, I'm not even attracted to you. And the skydiving company fired him, that tandem skydiver. And so that's kind of what was going on in those cases. And then in the third one, it involved a guy who began working his employment in a funeral home as a man, later identified as a woman, underwent gender reassignment, and when returned back to work wanted to dress and behave as a woman. And the funeral home said, that's off-putting to people and grieving families, and you can't do that and continue to work here. So that's a little bit of what was going on. And in none of those cases are we talking about a religious employer, a church, or a religious organization or something like that. And the court's analysis would have been completely different if we were, because of this doctrine of the ministerial exception and religious freedom. But because that's not what it was about, here's what Gorsuch had to say about these three doctrines. He said, how these doctrines protect religious liberty, interact with Title VII, are questions for future cases. And so he said, we're going to leave that open. That's not something we're addressing directly yet, but it will be, and we're about to get there. There is a case pending before the Supreme Court. So when he says that's a question for future cases, one of those future cases is already pending in the Supreme Court right now. So I think it would be helpful to know, when we're about to talk about this case that's pending before the Supreme Court, what might happen, what's going on in the country in light of this Hosanna-Tabor ruling, how are the circuit courts, the appellate courts, interpreting these four factors. I think it would be helpful to look at a few example cases. So we're gonna do that. The first case comes out of the Second Circuit, which is up in the Northeast. It covers New York, and the case is called Penn versus New York Methodist Hospital. That case came out in 2018. That ruling did from the Second Circuit, and there was a man who was a chaplain at New York Methodist Hospital who was terminated. He claimed they had illegally discriminated against him based on race and also based on religion. Now, the Second Circuit looked at that case and applied the ministerial exception, which is a big deal for a couple of reasons. One, they said that New York Methodist Hospital counted as a religious employer. And this employee had argued that it didn't count because while it had Methodist in the name, it had long jettisoned its religious roots and Methodist roots and had even actively portrayed itself and sought to behave like a secular hospital would, distancing itself from any kind of religious beliefs or Methodist traditions or beliefs. And the court said, no, it's a Methodist hospital, it's a religious employer, it still applies. Second thing was it applied to a chaplain. So doesn't necessarily have to be someone who's a pastor at a church. And so they applied it to the chaplain and they said, your claims of discrimination on both race and religion are barred. And that was in New York in 2018. In the Fifth Circuit, which covers Texas, so it's very relevant to our SABA churches and organizations around here, there was a case called Canada versus the Catholic Diocese of Austin. What happened in that case was an employee was terminated by the Catholic Diocese of Austin, and this employee was a music director, and the music director had some religious functions. He accompanied the choir with the arrangement that they played and sang on Sunday mornings, but he also had a lot of secular jobs, including arranging music and organizing budgets and balance sheets and things like that for the music department that were not traditionally considered to be overtly religious functions. Managing the equipment, making sure that the technology was working properly, that kind of stuff. So he argued, hey, I don't perform an important religious function. I perform mainly secular functions. He also argued, I'm the music director, not the music minister. I haven't been to seminary. I don't have any kind of special training or licensing for this position. And the Fifth Circuit, our circuit, the one that controls Texas, disagreed. They said, no, just by playing your instrument and accompanying the choir is an important religious function. And you don't have to be licensed or ordained or have gone to a seminary or have formal training to contribute to the important religious functions of the church. So even though they only do a religious function for a few minutes a week, half an hour or an hour a week, that's important religious work, and so musicians are covered. Even though we would traditionally not think of them as ministers, they're covered by the ministerial exception. A Sixth Circuit case called Conlon versus InterVarsity Christian Fellowship dealt with an employee. She was a spiritual director for InterVarsity, which is a collegiate ministry group. And when she became estranged from her husband at the time, and she told InterVarsity she was thinking about getting a divorce, InterVarsity had this clause in her employment agreement that they would attempt reconciliation. When reconciliation wasn't working or it was clear that it wasn't going to happen, InterVarsity terminated her. And she claimed, very relevant to our topic on this with Bostock, she claimed discrimination based on sex, because that includes typically marital status. And so she claimed that InterVarsity had illegally discriminated against her under Title VII, and the Sixth Circuit disagreed and said that they didn't disagree that she hadn't been discriminated against. They disagreed that Title VII should apply to her claims. They said, InterVarsity is a religious employer, and you're a spiritual director, and that's a minister that falls under the ministerial exception. And they applied that claim. And then the last one that I want to talk about where the ministerial exception barred claims under Title VII is a case called Gruscott versus Milwaukee Jewish Day School. And that one comes out of the Seventh Circuit. That one was in 2018 as well. And again, it was similar, a Jewish day school, important religious functions, not terribly different from the Hosanna Tabor case. And the court said, you know what, you're a minister, even as a teacher, you're a minister. And so you are prohibited from bringing Title VII claims. Now, that's not to say that every jurisdiction, every circuit court is interpreting the ministerial exception that broadly. It's not to say that every court is seeing it the same way. There are some jurisdictions that are not applying it that broadly, and one of those jurisdictions is the Ninth Circuit, which covers California out in the West Circuit. And there are two cases. One is called Beale versus St. James School, and the other one is Morrissey Baru versus Our Lady of Guadalupe School. And in both of those cases out in the Ninth Circuit held that these teachers at these private schools were not ministers under the ministerial exception, and so they could proceed with their discrimination claims under Title VII. And one of those cases, a teacher, I said under Title VII, actually they weren't Title VII claims. And one of those, a teacher was claiming age discrimination under the ADEA, and in another one, the teacher was claiming disability discrimination because of her disabilities under the ADA. And so those are actually different statutes from Title VII, but it's the same analysis, and the ministerial exception applies to all of those. And so Ninth Circuit said it doesn't apply. And even though the teachers did important religious functions, they taught, these were Catholic schools, and so they taught Catholic principles out of a Catholic workbook, half an hour every day to the kids at the schools. And the Ninth Circuit said that's not good enough. You don't have to be licensed or trained in anything like that, and that's not good enough to be considered a minister under the ministerial exception. And so they've appealed, and that case has been heard by the Supreme Court. They heard it just last month in May. And so when Justice Gorsuch says, How this is going to be applied to religious employers, this protection, is going to remain to be seen. Well, there's a case pending right now. It's not about the definition of sex, it's about age and about disability, but whether the ministerial exception is upheld in the Supreme Court case and whether it applies to these teachers out in California is going to have a profound effect over religious employers in Texas as well. And so that case is pending right now. Those two cases, they've consolidated them, they're hearing them together, two different cases, same issue. And so I want you to be aware that that case is pending. Be listening, have your ears perk up when that ruling comes down from the Supreme Court. SABA will have resources for you. I'm available to you, and that's something that we're keeping an eye on. And then very briefly, I want to talk about the third doctrine that Gorsuch mentioned in his opinion that protect churches. Remember, the first one he talked about was the express exemption from Title VII. The second one was the ministerial exception. And the third one is called the Religious Freedom Restoration Act. We call it RFRA for short. RFRA was passed by Congress in 1993 without a single opposing vote in the Senate or the House. And that's pretty remarkable because I can't think you could have a resolution that the sky is blue today, and I don't think that you could get that to pass, the Senate and the House without a single no vote. I mean, it had overwhelming bipartisan support, which is pretty remarkable. And what it says is that when the government is passing a law to achieve a certain compelling governmental interest is the language it uses. They have to do that in the least restrictive means possible on your religious freedom. And so the example I like to use to kind of give an example of that is if I wanted to sacrifice goats as part of my religion, and there was a case in Dallas where this happened. Someone was sacrificing animals. They were sacrificing goats as part of their religion. And the city of Dallas said, you can't do that. It's not sanitary. The blood gets in the groundwater. It endangers your neighbors. You just can't do that. And so they just prohibited it, point blank. And this gentleman sued under the Religious Freedom Restoration Act, and he won because the argument was, yes, the city has a compelling government interest in safety and sanitation, but they can't just blanketly bar this from happening. They have to provide a means where it can be done in a safe manner. There has to be a way that doesn't intrude on the religious beliefs as much. You could see how if it was different, if he was sacrificing human beings, saying I have to sacrifice virgins to my God, right? The compelling interest of the government being to avoid murder, that they could have a blanket, you're not going to be allowed to do that, right? And so it's this, what Gorsuch refers to as a super statute. He says it like this. He says, RFRA operates as a kind of super statute, displacing the normal operation of federal laws, and it might supersede Title VII's command in appropriate cases. And so what he's saying is, yes, there's this statute that says you can't discriminate when hiring, but then there's this super statute that says it's got to be as least restrictive on religious freedom as possible to accomplish the state's goal. What's the government's compelling interest? Avoiding discrimination against people because of these protected characteristics. But are they doing it in the least restrictive way possible? If not, and they're infringing on freedom of religion, then that's not going to be allowed. And so there are some cases that have kind of dealt with this employment context. One is, this isn't specifically a RFRA case, but the Equal Employment Opportunity Commission had a case against Abercrombie and Fitch. And what happened was Abercrombie and Fitch had this policy that you had to look cool, you had to look sexy to be able to work there, and that included no headwear of any kind. And so a Muslim woman who wanted to work there wore a hijab, and she was not allowed to work there because she wanted to wear this head covering, and it wasn't cool enough, it wasn't sexy enough for Abercrombie's look and the way they wanted their employees to look. And the Abercrombie lost that case based on freedom of religion. You couldn't discriminate against someone in employment like that. A couple of other important religious liberty cases that aren't directly in the employment context, but RFRA cases, you probably remember them. One was called Burwell versus Hobby Lobby, and the other one was called Zubik v. Burwell. And they had to do with the mandate from the Affordable Care Act of providing certain types of pregnancy drugs. Some call them abortifacient drugs, the ones that were in dispute. And so they were, the type like a morning after pill or Plan B, that kind of thing. And said, we don't want to have to do that. That's akin to abortion. We don't want to have to provide those. And so under the Religious Freedom Restoration Act, Hobby Lobby ultimately prevailed on that claim, even though it was a corporation. And then later in Zubik v. Burwell, a bunch of religious colleges Baptist universities also prevailed on that claim and that as well. And then just really recently, a case you probably remember well from the news called Masterpiece Cake Shop versus Colorado Civil Rights Commission, had to do with public accommodations and whether this baker in Colorado was required to decorate a cake for a couple for their same-sex wedding. And the reason that I bring that up is because the Religious Freedom Restoration Act, RFRA, it's a federal law, as I mentioned earlier. Some states have state versions of it. Texas has one. Texas has a state RFRA. And the state RFRA is identical to the federal one. And all they did was replace the federal government with Texas government, and it applies to the Texas government. Colorado does not have a RFRA to protect their businesses. And in fact, they have the opposite. They have a public accommodation law, and that public accommodation law says you can't discriminate based on someone's sexual orientation when providing these types of goods and services, and it included the baker. And so he said, hey, that violates my religious freedom and my religious liberty. And that case went up to the Supreme Court, and the Supreme Court decided in a 7-2 opinion just in 2018. They agreed that Colorado had been hostile and adverse to his religious interests, and they sent it back down and said, you need to recognize his religious subjection, even though there was no state RFRA in place. In Texas, though, we don't have that issue. We have a state RFRA, so we're protected by two. We're protected from federal laws like Title VII. Title VII is a federal law, or the ADA or the ADEA, and from local laws. And the reason I mention local laws is because San Antonio has its own non-discrimination ordinance or equal rights ordinance. Other cities in Bexar County may not, so depending on where your SABA church is, you may or may not fall under that. And so to the extent that makes religious exceptions, that order makes religious exceptions for churches and things like that, then it probably complies with RFRA. But to the extent that it doesn't make exceptions, then it may be in violation of RFRA. And so it's important to note that there are extra protections in Texas as well. So that's really what I wanted to say about the employment context. I know that was a lot of time on the Bostock case, but it just came down last week. It's an important case, and I really want you to know about this pending case out of the Ninth Circuit with these teachers, and we're going to see how it applies to religious schools. So as we're talking about modern applications of religious liberty and what that looks like in today's society, the next thing I think that's probably really appropriate and important for us to talk about is religious liberty as it interplays with the coronavirus, because right now we're in the middle of the COVID-19 pandemic. We hope it's the middle. Well, actually, we hope we're near the end. But we're in the middle of that, and what are the rules for churches, and how does our freedom of religion interplay with the need for public safety? Again, going back to that analysis we talked about a moment ago of the government has a compelling public interest in safety. It actually happens to be aligned with the church's interest. We share that interest in safety and protection of our neighbors and the most vulnerable among us. But also the need to be able to worship and freedom of worship, and what does that look like, and what does that interplay look like? In Texas, Governor Greg Abbott has issued a series of executive orders. We're currently on Executive Order GA-26, and GA stands for Greg Abbott. And there's Executive Order GA-26, which is also kind of phase 3 of Texas reopening after our statewide lockdown and closure. And then there are these predecessor orders that came kind of before that. And in GA-26 and in each of the previous orders that covered this, Governor Abbott made an exception for churches. He made an exception for churches when it came to worship services. And he specifically said religious services are exempted from occupancy requirements and other restrictions and requirements, even back when before the governor's executive orders prohibited forcing people to wear masks, compelling people to wear masks. Churches were exempted from that. They're exempted from social distancing requirement, all that kind of thing. Now, churches should still do those things. I'm not advocating that churches don't social distance and that people don't wear masks when they worship, or that they don't limit their occupancy in some way. I'm not saying we shouldn't do that. But we're exempt. And why are churches exempt? Governor Abbott said it's because of religious liberty. In fact, when some of the orders were criticized as being infringing too much upon religious liberty, Governor Abbott released a joint statement with the Attorney General providing guidance for houses of worship, and a separate document from the executive orders, making sure churches knew and understood that when it came to religious services, they were exempt, and outlining what that looked like. Now, that's in Texas, but not every state has promoted religious liberty in the same way, and that's not the case in a bunch of other states. Particularly, I've noticed in the news and the headlines that in Nevada, as they've reopened that state, Las Vegas has been allowed with their casinos to have a much higher capacity, hundreds, sometimes thousands of people in the casinos, but there's a strict limit on churches of 50 people per gathering. And that limit isn't based on the churches or the church's size. For some people, for some churches, a smaller congregation or a smaller facility, 50 might really pack out that congregation. But what if you have a gigantic auditorium that could seat thousands, and to only be allowed to have 50 people in there? It doesn't seem fair, does it? It doesn't seem right. And so in some jurisdictions, some of these orders may violate religious liberty and religious freedom. Going back to our discussion about RFRA, yes, Nevada has a compelling interest in public safety and prohibiting the spread of COVID and trying to delay it as much as possible. But is a blanket rule of no more than 50 people, is that the least restrictive way of achieving that goal? Or could it be more narrowly tailored? For example, in Texas, Governor Abbott says 25% occupancy or 50% occupancy, something like that. Again, those occupancy requirements in Texas don't even apply. But if you follow the guidelines of leaving every other row of chairs or pews open and 6 feet between families, you're going to see a limited occupancy. And that seems so much more reasonable than just casinos can open with this much capacity, while churches can only open with this kind of capacity. And so we're gonna see in these types of issues with coronavirus that delicate interplay between the interest of public safety, preventing the spread of coronavirus, and in religious liberty and allowing churches to worship and that kind of thing. We're seeing it right now with the newest ordinance. There's in some counties, not every county, it's not a state order, but in Bexar County, where SABA is, in Bexar County, and then some other major counties, Harris County, Travis County, I think Dallas County, all have these new ordinances that are telling businesses, we're going to require businesses to have people wear masks, both their employees and their customers. And the language it actually uses is commercial entities. Now, I don't believe that those apply to churches, and it can be a little bit confusing because churches are commercial property. They're not residential property, so as opposed to a house or an apartment complex, they are commercial, but they're not commercial entities, right, as religious entities. Now, a nonprofit can be a commercial entity, but I don't believe churches are. But to the extent that they would be considered commercial entities, if they were to be, and if someone were trying to argue that this applied to churches, I think it would violate RFRA. I think it would violate the First Amendment. I think it would violate these state and federal protections that are in places for churches. And I think Governor Abbott would agree. And he's tried very hard to encourage churches to be safe and responsible without overstepping and intruding on religious liberty. So the coronavirus, how we wear masks, occupancy requirements, things like that, state orders, local orders from our county, all of those are modern day, right now, examples of how do we balance religious liberty with other interests and other rights. Religious liberty is an incredibly important freedom. Our First Amendment freedom is incredibly important. That's why we're calling this our first freedom. And it's going to create disruptions. Coronavirus is disruption, and trying to gather during coronavirus to practice our freedom of religion is a disruption right back. So it's going to create disruptions, but it's not an absolute freedom, right? As we already gave one example. It wouldn't give you the power to murder someone and say you had to do it because of your religion. So it may not be absolute. None of our freedoms are absolute, but it's our first, and it's arguably our most important of all the freedoms guaranteed us in our Constitution. There are a couple of pending Supreme Court cases I want to talk about. There are two pending Supreme Court cases that I want to talk about. One, actually, I've already talked about, which was the case pending from the Ninth Circuit that regarding employment. But I want to talk about two more that don't have anything to do with employment. These are separate cases. They're different. One is called the Espinoza versus the Montana Department of Revenue. And let me tell you a little bit about what's going on in Montana. This is a school voucher case. The state of Montana allows vouchers for schools. I don't know exactly how the system works, if it's like a tax credit or something like that, but essentially families can apply a certain amount of dollars per kid to that kid attending a private school. And it's some type of voucher or credit type system. And the issue is that after this started, Montana said, hey, we have this statute, this rule that's in our Constitution called the Blaine Amendment, and it says this. It says we can't use state dollars, state tax dollars, and give them to a religious institution for any kind of reason. And so what you can't do is you can't use this school voucher program and apply it to a religious school. So yes, you can have school vouchers, but only for non-sectarian, schools. And so you can only use it for, like a charter type school that's a private school, or a non-religious private school, and it excluded private schools. And so there's a group of private schools in Montana that are saying you can't do that. That's discrimination based on our religious beliefs. You can't include some and not others. And so the real issue in the case is not whether Montana should have school vouchers or not. That's a completely separate conversation for Baptists about what we believe about the public school system and vouchers. It's an important conversation, but not directly tied to what we're talking about today. The question is, if they're going to have school vouchers, can they exclude religious groups? Can they exclude churches from being a part of that? And so that's being considered by the Supreme Court right now in Montana. And that case is going to draw heavily on a previous case that was decided back in 2017 that you might remember. And that case was called Trinity Lutheran of Columbia v. Pauley. And what happened in that case, that was in Missouri, and there was Trinity Lutheran was a church with a playground, is a church with a playground. And Missouri had this program, this helpful program. They were going to recycle old tires. And so you paid part of a tax when you bought new tires. They taxed new tires. And part of that tax went to recycle the old tires to replace playgrounds with rubber, so that kids weren't falling on gravel and scraping up their knees and not getting hurt as much. They recycled the rubber from those tires and made these safe, bouncy playground surfaces. And it was a great program, but they could only do a certain number of them. And so you had to apply, and only a certain number were going to receive this grant that came from these tax dollars to get these resurfaced playgrounds. And Trinity Lutheran applied, and they were rejected. Originally they were accepted, and they made the cut, and they were going to get one, but then someone said, wait a second, this is a church, and it's a religious group, and we have a Blaine Amendment, just like Montana, that says we can't use government grants or tax dollars for religious organizations, and so we can't help Trinity Lutheran with this. And Trinity Lutheran said, it's a playground. It's not teaching kids religion, it's kids playing on a playground. You can't exclude us just because of our religious beliefs, and just because we're a church. And the Supreme Court decided in that case 7-2, that's right, you can't exclude Trinity Lutheran from this grant program just because it's a church. Now, how much of that will be applied to Montana? We don't know. But in a 7-2 opinion, the Supreme Court decided with Trinity Lutheran, and so it seems likely that the court will also side with these private schools in Montana and tell Montana, if you're going to have a voucher program, you can't exclude religious organizations just because they're religious. And so that case is pending, and we're waiting that opinion. We might have it by the time you see this video. The Supreme Court is releasing opinions every week, and we could have word of that even as soon as next Monday. So we'll see on that. The other case I want you to be aware of is called Fulton versus City of Philadelphia. And this has a lot to do with sexual orientation. And we just kind of had a conversation about it in an employment context. What does sex mean under Title VII? This is a similar type question, not with employment, but again with government dollars and also with government placements. Can the City of Philadelphia refuse to refer and place foster children with Catholic social services? And Catholic social services will not train foster parents that are in a same-sex relationship. So they will train married couples as foster parents, but they have to be a man and a woman in that relationship based on their religious beliefs. And Philadelphia said you can't do that. That discriminates against people based on sexual orientation. And so if that's going to be your policy, we're not going to send you any more foster kids, because we're not going to support you in that or participate in that. So we're not sending any more foster kids to you. And so a bunch of foster parents who were directly affected because they are no longer able to get foster children and help foster children through Catholic social services, who they've been trained by and equipped by and licensed by, they're not getting those cases anymore. They sued. So that case is pending before the Supreme Court, and we're waiting to hear what the Supreme Court has to say about that case as well. An important case regarding religious liberty and the religious liberty of foster agencies, and whether foster agencies can discriminate based on what they're saying these are our religious beliefs. We're discriminating based on religious beliefs. You have to share our views on marriage and on sexuality in order for us to place foster kids with you. So that's an important case that's pending right now, and we're going to want to see how the Supreme Court rules on that. It will affect SABA churches and organizations here in Texas. You know, there is a fostering and orphan crisis, and we need foster parents. And in a lot of situations, churches are answering that call. They're training and equipping and coming alongside people in their congregations that want to foster. They're supporting organizations in our community that help with fostering and with adoption. And so this case is going to be really important to the religious effort, to the effort of our Baptist churches in helping with that. And then one other case that I think that's worth mentioning. This is not a pending case. We're done with the pending cases. But I want to talk about a case that's already been decided. It just got decided last year, and so I haven't had the opportunity to discuss it with you yet. And that is the case of the American Legion versus the American Humanist Association. And that was a 7-2 ruling in favor of keeping a cross up as a monument, as a memorial. And so I wanted to talk a little bit briefly about that, because what was an issue in that case was there was a cross. The cross was set up to honor, as a memorial, honor people who had died in World War I. And that cross was originally on private property, but then it became public property, got purchased by the government, became public property. And the American Legion had this cross, and it was being maintained. It was sitting on government property, and the American Humanist Association said, you can't do that. That is public dollars promoting something that is religious and maintaining something that is religious. It violates separation of church and state. And in a 7-2 opinion, the Supreme Court said last year, no, the cross can stay. It doesn't have to be removed. It can stay. Now, their reasoning for that is less than ideal for Christians. Their reasoning is that the cross can have a secular meaning. Now, some Christians would strongly disagree with that and say that the cross always has an overtly religious meaning. But they said it can have a secular meaning, and in this case it did, because what happened, they said, was people saw these crosses for dead relatives and friends and people overseas who had died in the war. That cross reminded them of their sacrifice. And so when they were setting up a monument that they could visit, since they couldn't all travel overseas to see that, they wanted a cross that looked similar to that. And so it wasn't an overtly religious thing pointing to Jesus, they claimed, but a reminder of those who sacrificed in the war. So that was the rationale they used. It wasn't dissimilar from a rationale they used in another case where in Greece, New York, where they opened their city council meetings with prayer. The town of Greece did, and a group sued the town of Greece, New York, saying you can't do that. And the Supreme Court upheld the prayer before the city council meetings. Again, a good result, but a less than desirable rationale saying that prayers could have a non-religious meaning, which is kind of a bizarre ruling, but that the purpose of the prayer was not to proselytize or force people to believe in Jesus, but the purpose of the prayer was to convey the solemnity of the meeting, to get people focused on the task at hand, and that in both of these cases, the tradition and the history of Christian prayer and monuments and things like that factored heavily into the Supreme Court's decision. So that goes kind of back to my opening remark or principle about not seeing reductions of religious privilege as this reduction of or an infringement on religious liberty. That basically what the court said is the privileged status Christianity has enjoyed throughout history, praying before meetings, having crosses up, things like that, actually plays into their favor, and we're going to allow these practices to continue. So one last topic I want to talk with you about regarding religious liberty, and this is good news for any of you who are ministers. And when I say ministers, I don't mean ministers under the ministerial exception. I don't mean an instrumentalist or administrative assistant or something like that. I mean licensed or ordained ministers. I mean ministers under the IRS. Those of you who claim housing allowance exemptions. Hopefully you know what a housing allowance is. It's a portion of your salary that you don't have to pay income tax on, because it's designated to your housing. It's similar to the parsonage exception. The parsonage exception is a house that's owned or property that's owned by the church or the organization that they allow that minister to live in. That's a benefit and usually would be a taxable benefit for another employee, but it is not taxable for churches. The problem with the parsonage exception is it favors certain denominations and it favors certain institutions that have property, that have houses, as opposed to, some of, for example, a hierarchical denomination may have a lot of property and a lot of houses that they can put pastors in. Baptists used to have a good number of parsonages, but not as much anymore. Sometimes Baptist churches meet in schools or movie theaters. They don't even own their own building for worship, let alone a house for the minister to live in. And so they're being excluded from that benefit. So what the housing allowance does is it says, okay, you may not be able to provide that minister an actual house, but if you provide them a portion of their income that goes towards a house, we're going to allow that to be tax-free as a benefit to them as well. And so we know that not every church can pay their minister a lot of money. You did not get into the business of ministry to try to get rich. You're serving the Lord and serving your calling, and so those tax-exempt dollars from your income go a long way. And so if that parsonage exception, the housing allowance was removed, or the parsonage exception was removed, that would be a really difficult thing for a lot of our ministers in their pocketbooks. And there was a challenge to it. There was a challenge from the Freedom from Religion Foundation, not Freedom of Religion, Freedom from Religion Foundation, an atheist group up in Wisconsin. They challenged that and said this is unconstitutional because our atheist ministers don't get the same benefit. And atheist minister sounds a little bit like an oxymoron to me, but that's the argument that they made. So they won at the trial court level, and then the appellate court, the circuit court, they threw it out. They said, you haven't even tried to apply for this benefit, so how do you know that you're being discriminated against? So they applied for the benefit, the IRS denied them the benefit, and so they went through the process again, and they won again at the trial court level. No surprise, it was the same judge. And then they tried again at the appellate level, and the appellate court had to decide on this again, this time on the actual merits of the case, not whether they had a right to complain. And the court said, no, the housing allowance does not violate the First Amendment. It's allowed to stay intact. Now, that's only an appellate court ruling for that jurisdiction. It's not binding on the country at large, but something, and that was the Seventh Circuit, that was Wisconsin. But that was in March of 2019 that the appellate court said the housing exemption doesn't violate the First Amendment, the housing allowance stays. In June, that was when the Freedom from Religion Foundation had a deadline to appeal. They could have appealed it to the Supreme Court, to the United States Supreme Court, and they didn't. They let the deadline pass. They chose not to appeal. And in a press release and answering questions, they essentially said the makeup of the court isn't right. This isn't the time to challenge it, because they knew they would lose at the Supreme Court level. As I said earlier, Supreme Court is very pro-liberty. That includes pro-religious liberty. Our court has consistently sided on behalf of churches and ministers and those asserting religious liberty claims, at least under our current Chief Justice. The Roberts Court has done that. And so they didn't even appeal. So right now, the challenges to the housing allowance are dead. They're stopped. That's not to say that a challenge couldn't come up in another circuit, the Ninth Circuit maybe, or a different circuit, Second Circuit, something like that. But currently there aren't any. And I'm confident that if it got taken to the Supreme Court, at least as currently constituted, the housing allowance would be there to stay. So continue claiming those housing allowances, continue enjoying and benefiting from those right now, without the fear that those are going to be ruled unconstitutional, at least for now. Just again, another promotion of religious liberty and freedom, not taxing the housing of our ministers. So those are, I know that's kind of a catch-all. It's kind of some miscellaneous issues that are going on right now, but that kind of catches you up to date on some of the religious liberty issues, at least as they're being applied with legal challenges and in courts. And again, I'm an attorney, and so that's what I know. And so I hope you have a good Independence Day, and I hope that you appreciate on this Independence Day the brilliance of our First Amendment, the brilliance of a country that has it's not perfect, but has the best system that we know of for balancing the rights and liberties of individuals, including our religious liberties and our freedom of expression and freedom of worship. And so we're grateful for those opportunities. We're grateful for those who fought and continue to fight for us to have those religious liberties. So I hope you appreciate those. appreciate your Southern Baptist heritage, appreciate all of the work Baptists have done to contribute to this amendment and these freedoms and the continued freedoms we enjoy today. And thanks a lot for your time. I hope I get to see you in person again real soon.